नहीं होता आज के टाइम में। तो okay, so hello everybody, good afternoon and welcome back to the Edu for IS, the live Hindu class. Today the date is 18th of August and we are starting with yesterday's question first. Fine. So जो questions आपको दिए गए थे from the yesterday's Hindu this discussion, let us first solve them. So first question is related to the PM Vishwakarma scheme. The scheme will be available for traditional craftspeople and artisans from 2023-24 to 28-29. We covered or we discussed this article in detail. So I hope you can recall what was, and you have tried to solve it. Fine. So those of you who have tried or solved it, please put the same in comment section, your correct answers or whatever answers you have marked for this question. Next, the scheme aims to strengthen and nurture the Guru Shishya Parampara or the family-based practice of traditional skills. Next is 18 traditional trades such as this carpenter, boat maker, etc. will be covered under the scheme. Under the scheme, a stipend of 1,000 per day will also be provided to the beneficiaries. So what should be the correct answer here? Remember, first in the first option, the issue is with this. It's not 28-29, it should be 20-27-28. Fine. So that's why first statement is wrong. Second, of course, Guru Shishya Parampara and this traditional family-based practice of traditional skills is very much correct. Second is of course correct, it was 18 only. Fine. And fourth one is under the scheme a stipend of not its 1,000 but rather 500. Fine. 500. So therefore, your fourth statement is also wrong. So out of 4, we are left with just 2 pairs as correct. So only 2 pairs are correct. Option 1, option A. Next question was related to the Bihar government's order notifying the caste-based survey is unconstitutional, since only the center is exclusively authorized to conduct a census under the constitution. You had to critically examine this statement for 10 marker and in 150 words. Fine. So we discussed yesterday the Bihar government this caste-based survey which has been going on. Finally, the second phase of this survey is already undergoing. So there are certain issues we discussed. What are the issues and all constitutional questions put by the petitioners? And today is the date of August 18 when the Supreme Court will be hearing this petition. Fine. So first of all, how will be writing these answers? So of course, following the same structure. Intro, body and conclusion. So what comes where? So when the question is, I have said time and again, 10 marker, please do not try to go for more than 3 lines or more than 30-40 words for your introduction. Fine. So you can start with what exactly is a caste-based survey. Fine. Or you can give some background of the same, like for example, the state government of Bihar launched a 2-phase caste survey. Stating that detailed information on socioeconomic condition would help create better government policies for disadvantaged groups. That's it. Just 2-3 lines of your introduction. After that, you can build up on your introduction and continue with the same in the body part. उसमें आप ये कह सकते हो कि the census conducted at the beginning of every decade, हर 10 साल पे हमारे यहाँ conduct होता है census, fine. बट उसमें सोशियो और जो कास्ट बेस्ड सेंसस है उसको कंसीडर नहीं किया जाता, ध्यान रखना, कल भी हमने इसको डिस्कस किया था. सो देयरफॉर द नीड वाज फेल्ट टू हैव सच काइंड ऑफ सर्वे एंड देयरफॉर द सेंसस कंडक्टेड एट द बिगिनिंग ऑफ एवरी डेकेड और एवरी 10 years does not record any caste data other than for those listed as scheduled caste. In the absence of such a census, there is no proper estimate for the population of OBCs, various groups within the OBCs and others. So therefore, the need was felt, or the need of R is to take such kind of or conduct such kind of census. Fine. But in this, you can also mention the article itself that we discussed, that why the need for a caste census actually. So you can give the same heading, need for caste census, and you can jot down the or list down the points whatever we've discussed under this article. For example, you can mention here the OBC and especially you can quote here the Mandal Commission report of 1992, where the then VP government at the central level, granted 27% of reservation to the OBCs based on BP Mandal Commission recommendations. Fine. And then further you can mention that subsequently in the 1992 itself, Supreme Court ruled in a famous case called Indra Sawane versus Others versus Union of India, 1992, in which the Supreme Court underlined that this reservation should not cross, because the BP Mandal Commission underlined that OBC population stands at 52%. It doesn't mean you can give 52% of reservation to the OBCs. No, there are other castes in India as well, SCs and scheduled castes and scheduled tribes as well. They also deserve, this reservation or affirmative actions, you can say. So therefore, in this very famous case, Indra Sawane versus Union of India, Supreme Court underlined that the reservation that is granted to, across, taking into account the different castes and all, it cannot cross more than 50% in general pool. Let us say, so 50% of the seats should go to a general and rest the 50% for the reserve category for the caste. Fine. So therefore, this thing can also be mentioned, and then you can give another heading that why or what are the challenges or why it is being challenged in the Supreme Court. And then you can further list down the points on the basis of which this has been challenged that we discussed yesterday. Fine. For example, the petitioner contend that the state, this order notifying the survey, caste survey, is unconstitutional, since only the center has such kind of authority to notify such kind of what? Census. Then, but you can also continue that, however, the central government, the central government, be it any government, the official this policy of the central government has been since 1951 is that of official discouragement of caste, and therefore further on this line in 2011 actually the socio-economic caste-based census were indeed conducted, but the final report of that could not be made public or put in the public domain, considering some ambiguities in the data itself. Fine. So the collected raw data of nearly 130 crore Indians in 2011 was never made public due to flaws in the data itself. So this is how you can try to maintain neutrality in your stance, giving both pros and cons, mentioning what is the need of R, what is the stand of judiciary, mentioning the Indra Sawane case, and then mentioning that why it has been actually challenged. Fine. So this is how you can build up on the intro, body, and conclusion. Fine. So that should be the ideal structure of your answer. Okay. Let us now move to the today's Hindu itself and let us start our discussion. So सबसे पहले हम first page देखते हैं, and then we'll be taking we'll see the questions as well from the today's discussion itself. बस उससे पहले हम discuss कर लेते हैं चीजों को. So Chandrayaan propulsion lander modules separate. Yes. Chandrayaan में propulsion and lander modules जो हैं, they have been separated. We have discussed this article 2-3 times, even in our current affairs classes as well. So you see, finally the date is August 23, when we are waiting for this lander to make soft landing on the surface of the moon, especially on the south poles of the moon. Fine. So this lander module is set to descend a slightly lower orbit upon a deboosting. Deboosting is what? Actually, when you are decreasing the speed of your this Chandrayaan 3, fine, or you can say the lander itself. Planned for today. So deboosting will start from today only, and today is the 18th of August. So it will take 5 days almost, because somewhere the challenge is somewhere you are going to reduce the speed from 2500 km/h to somewhat, let us say 10 km/h. So this is a challenge. You can imagine that when a vehicle is, let us say a car is going at the speed of 2500 km, so there is a limit to it, but let us assume, and then you have to control it and bring it to the 10 km/h. When you when you try to do this, there are chances of accidents as well. Fine. So that's why this is a very, very challenging part of the whole mission. Fine. Success and failure depends on this only, and we call it soft landing, because here we need to deboost and reduce the speed. Fine. So this is what soft landing in simple terms means. Okay. So this is what the ISRO has started doing from today's only. Okay. So that much. बाकी 23rd को जैसे भी update जो भी हमारे को next 3-4 days में updates मिलते हैं, we'll be keeping tab on that. So no more bulk SIM cards as government steps in to curb fraud. And yesterday the government released this data of 52 lakhs connections of the SIM cards which have been fraudulently, taken by the people. So recent efforts to curb fraud in mobile connections have led to the blacklisting of 67,000 SIM dealers, 52 lakh connections, and the registration of over 300 FIR. Fine. So new system has been created in order to put a check over the cyber crimes and all, and to stop the people from taking SIMs in bulk. So therefore, the facility to provide SIM connections in bulk to companies is being discontinued, and instead a business system is being put in place where they have to undertake KYC, know your customer. अब बैंक अकाउंट अगर आपका है तो वहां भी मैंडेटरी हो गया आजकल KYC कराना when a SIM is being issued to them. So अब क्या होगा कि बल्क SIM की जो प्रोविजन होती थी उसको शिफ्ट करके चेंज करके क्या कर रहे हैं, now there is a new provision which is called business system. Fine. The existing bulk system requires companies to preserve records of individual subscribers. So a transition period will be provided for bulk subscribers to get themselves verified under the new regime. This was said by our Information and Communication Minister. Fine. This. So defense and law, but there are certain exemptions to this as well. For example, government, defense, and law enforcement bulk subscribers will continue to be exempted from additional verification requirements. Fine. So keep in mind this much of the things. So these are exemptions given to the different government related agencies. Then you see inflation to be well above 6% in Q2 of this year, this current fiscal year. Fine. Said by the RBI. Currently it has somewhat breached the 6% of upper limit of RBI limit to control the inflation in this range of 4 plus minus 2%. So just 2 days back we have this report that CPI stands, or retail inflation stands 7.44%, which is more than 6% of the upper limit of RBI. Now drones to monitor progress quality of assets produced at मनरेगा वर्क साइट्स. तो जो भी मनरेगा के अंडर में काम होते हैं उसके लिए अब ड्रोन्स की प्रोविजन की जाएगी, एंड मिनिस्ट्री जो इसको देखती है दैट इज मिनिस्ट्री ऑफ रूरल डेवलपमेंट. So the ministry is placing drones into service to monitor both the progress and the quality of assets being produced. इसके अंदर काफी करप्शन के चार्जेस भी लगते हैं कि कुछ लोग काम कम करते हैं या कुछ फ्रॉडेंटली भी प्रैक्टिसेस, कुछ फ्रॉड रिलेटेड प्रैक्टिसेस भी इसमें देखने को मिलते हैं कि घोस्ट नेम्स क्रिएट कर दी जाती है कि हाँ जी इन्होंने भी काम किया, इन्होंने भी काम किया, एंड गवर्नमेंट उसको फिर पैसे देने पड़ते हैं, वेजेस देने पड़ते हैं, रेम्यूनरेशन. फाइन. सो देयरफॉर टू चेक ऑल दिस द मिनिस्ट्री हैज कम अप विद सच काइंड ऑफ provisions. So there are 4 functions mainly to be performed by these drones. So according to ministry's SOP, that is standard operating procedure, recently released by the ministry, the drones will be used for 4 types of monitoring. Number 1, surveying the ongoing works, inspecting the completed works, and impact assessment, and finally special inspection in case of complaints. ठीक है. इसके लिए एक प्रोविजन की गई है that is of ombudsperson in every district who is responsible for registering suo motu complaints and disposing of them within 30 days. ठीक है. So this is what the provisions been made for this, and this is a good thing you can say. So drone will especially be helpful in such cases for real time monitoring and for garnering evidence. ठीक है. So this is a new addition related to, or something additional information related to your मनरेगा's monitoring. Mahatma Gandhi National Rural Employment Guarantee Scheme. Fine. Okay, moving to the city page from Delhi. Not that, you see, only politics. So not that much, not that relevant. Next is your ad page. Again, you can skip this. And next page from the states, you have lots of politics here. So you can see clearly. Fine. So politics and politics only, and to some extent violence and all. Okay. Finally, the next states related page. So Indians stranded in Niger cross border enter Benin. Fine. So Niger में तख्ता पलट हो गया, वहाँ पे मिलिट्री रूल कर रही है, डेमोक्रेटिकली इलेक्टेड गवर्नमेंट को ओवरथ्रो कर दिया है. ठीक है. So this is where even the Ministry of External Affairs has issued advisory to the Indian citizens who are residing in Niger to come back, or you can say leave the Niger. So this is how the things are going on related to that. Okay. Apart from that, you have politics only. Okay. 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 Next is states page. Again, you have politics. You can see here, and violence. Okay. So let us not waste time here. Quickly, yes. So here comes your editorial page, and that's important for us because the first article, the lead article on this page, is related to the recent amendments that are being made to the births and deaths registration, which has become act now with the assent of the president finally, and therefore the writer himself has been the deputy, registrar general, you can see, of civil registration, government of India. So therefore, he's the right person to actually evaluate this. And gaps in birth and death registration amendment act. So whatever provisions have been made under this act, he is actually underlining that where is the gap, whether there was a need for such an act or not, or what are the different provisions, and how the state and the center actually undertakes this registration of birth and deaths in India. Fine. So let us quickly discuss this. First comes the background. So the Registration of Births and Deaths Act, RBD Act 1969, remember, provides for compulsory registration of births and deaths under uniform law across India. ठीक है. So हमारे पास जो act है, the original act, this one is amendment to this, that is RBD, that is Registration of Births and Deaths Act 1969, which provides for compulsory registration of births and deaths across India. So experience of its working indicates that it is necessary to amend it for several reasons, and things could be changing as bill to amend this act called the Registration of Births and Deaths Bill 2023 for the first time since its inception has been passed by the parliament and has got the assent of the president of India, and therefore this bill has become now the act. Fine. Amendment Act. So he is mentioning that of course with the changing time there are various reasons to actually bring amendment to this, and since its inception in 1969, this is for the first time that government has brought some amendment to it. Okay. So therefore one of the major objectives जो थे इस bill के, that was to create a national and state level database of registered births and deaths which would help in updating other databases, resulting in an efficient and transparent delivery of public services and social benefits. So this is one of the important objectives that was mentioned under the statement of objects and reasons. तो कोई भी बिल जब सरकार लेके आती है तो उसमें प्रीएम्बल काइंड ऑफ इंट्रोडक्शन में ही बताना पड़ता है सरकार को कि हाँ स्टेटमेंट एक देनी पड़ती है कि हमारी ऑब्जेक्टिव क्या है इस बिल को लाने की, एंड साथ में रीजंस कि हम क्यों ला रहे हैं. ठीक है. So we call it simply the statement of objects and reasons. So this is the objective. Now it comes now the thing about building database. So for building database purpose, the bill makes it compulsory that the Registrar General of India maintains a national level database of births and deaths. Remember, Registrar General of India this comes under the Home Ministry. ठीक है. And that the chief registrar of births and deaths in every state is required to maintain a state level database of registered births and deaths. तो यहाँ से दो चीज़ों की क्लैरिटी रखनी है कि रजिस्ट्रार जनरल ऑफ इंडिया जो है वो मेंटेन करेंगे एक नेशनल लेवल डेटाबेस, एंड रिस्पेक्टिव चीफ रजिस्ट्रार जो रिस्पेक्टिव स्टेट्स में है अक्रॉस इंडिया, सो वो लोग मेंशन करेंगे देयर स्टेट लेवल databases of registration of related to births and deaths using the portal approved by the Registrar General of India. So these databases are to provide information to update the National Population Register (NPR), the Aadhaar database, electoral rolls, ration card, passport and other databases at the national level as may be notified. तो जो ये रजिस्ट्रेशन एक डेटाबेस हम तैयार कर रहे हैं, ठीक है, नेशनल एंड स्टेट लेवल, so for what good reason we are doing it? So of course we are doing it to use this database of births and deaths related information for all these purposes, from NPR, National Population Register, to the Aadhaar database, to electoral rolls, fine, and can be used for verifying the same, means verifying the identity of person, especially related to the percentage. So कई बारी birth certificate आपसे मांगी जाती है for different purposes. So government can use this the data from this database itself. So in the case of birth, the amendment provides for collecting the Aadhaar number of the parents. Nothing is mentioned about the Aadhaar number of the deceased. जिसकी मृत्यु होगी, जो जिसकी डेथ होगी, उसका क्या? So nothing has been mentioned under this. So this is the first gap, you can say, or the point of criticism. He is criticizing it. So updating many of the databases would require removing the names of the deceased from the database. Fine. If the Aadhaar number of deceased person is not collected, it would be impossible to achieve this objective. So this is how he is actually criticizing this, that if you are not asking for or not verifying the Aadhaar number of the deceased, then of course this whole exercise of updation is somewhat would not be achievable. So this means that the laudable objective of ensuring efficient and transparent delivery of public services and social benefits would remain a dream. So of course database बनाने का एक reason ये भी है कि of course we want to have efficient and transparent delivery of public services as well. Fine. So do we need the central and state databases of births and deaths? That's the question he is putting. So the registration hierarchy is the responsibility of a state government, with the Registrar General of India having only the role of coordination and unification of the registration system. So you can see the clear cut जो domain है, that is of state. कि जो डेटा कलेक्ट करनी है रिलेटेड टू बर्थ एंड डेथ एंड रजिस्ट्रेशन करनी है, दैट इज ऑफ द स्टेट. सेंटर का रोल बस इतना है कि जो रजिस्ट्रार जनरल ऑफ इंडिया है RGI, he will be having only the role of coordination and unification of whatever data has been collected by the states. The maintenance of the central database is being added to the Registrar General of India's functions. Fine. So new function has been added to the RGI. The chief registrars are the executive authorities for the matters related to registration of births and deaths in the states. Indeed, so they need to maintain a database for efficient delivery of services of providing birth and death certificates, and are doing so in many states even now. So this exercise has already been done in it's being done in many of the states even now. Nothing new in this. The national database is going to be nothing but a collection of state level databases. So national database is nothing but collection of state level databases, because ultimately states are at the forefront, you can say. State this register state at the state level, the officers actually related to this, to whom we call what? Yes, chief registrars, of course. So at the state level they are actually going to register and collect the data related to the births and deaths. Registrar General of India, and they will have to collect this data or to register the births and deaths as per the standards prescribed by the Registrar General of India. So if the authorities maintaining other bases require information on births and deaths, it is possible to design a system wherein the required data flow to their database on a daily basis or even on a real-time basis from the state level database. तो इसमें ये कह रहे हैं कि कहीं ना कहीं अगर different databases maintain कर रहे हैं, not just related to births and deaths, so those authorities, if they need some data related to the births and deaths, such kind of data can be provided to them either on the real-time basis or either through on daily basis. So the Registrar General of India needs to specify the standards for the data structures and transfer protocols, that how the data would be transferred from one authority to the other, let us say, or from one department to the other. So what is the need for a national level database? Next question. It is provided that this database at the central level be made available to authorities dealing with the maintenance of, let us say, and preparation of databases related to the population register, electoral rolls, Aadhaar number, ration card, passport, driving license, property registration, and such other databases at the national level as may be. So होगा क्या कि अगर birth related, death related जो भी registration, जो भी databases हैं states ने collect किए हैं, उसको क्या है कि link किया जा सकता है in for different purposes, for electoral rolls, for preparing electoral rolls, for let us say issuing ration card, passports. Fine. So for these purposes, central government actually can use such database. So listing a few databases for consideration by parliament and leaving future addition to the government is demeaning to the parliament in a way. Fine. Why so? Because the RBI Act only needs an enabling provision to share information from the database. जो भी हमने ये बात की है सारी, इसके लिए क्या है कि सिर्फ RBD जो एक्ट है हमारा, उसमें एक एग्जेक्टिव लेवल पे प्रोविजन करने की जरूरत है, उसमें अमेंडमेंट की जरूरत नहीं थी। सरकार सिर्फ एक एग्जेक्टिव ऑर्डर के थ्रू भी इसको इम्प्लीमेंट कर सकती थी, ठीक है, कि हम इन पर्पसेस के लिए जो स्टेट की डेटाबेस है उसको हम यूज करेंगे, ठीक है। सो देयर इज नो नीड of amendment as such for such kind of provisions. So new additions to this list later may be more dangerous than those listed and approved by parliament. For example, the government can now decide that a list of women whose third or higher order birth is being registered be prepared and given to the family welfare department for follow up on family planning programs. So he is skeptical in this sense that कुछ प्रोविजंस हैं वहां पे ये वर्डिंग्स हैं कि कुछ चीजें हमने ओपन रखी है सो दैट कि एज द टाइम इवॉल्व्स विद चेंजिंग दिस ट्रेंड एंड ऑल, सो नीड ऑफ आर जैसे भी फील होगा फेल्ट होता है ऑन लेटर टाइम्स, तो हमने ओपन रखा है इसको कि वहां पे हम जो भी इवॉल्विंग चीजें हैं उसको भी हम अकोमोडेट कर लेंगे। बट वहां यहाँ पे राइटर जो है स्केप्टिकल है, ही इज गिविंग एन एग्जांपल दैट फॉर एग्जांपल अ लिस्ट ऑफ वुमेन हुज थर्ड और हायर ऑर्डर बर्थ, सो एक वुमेन की लिस्ट अगर प्रिपेयर कर रहे हैं, डेटाबेस तैयार कर रहे हैं जो जिसके कि लेटर से थर्ड और मोर देन 3 चिल्ड्रन है, सो सपोज वहां पे वो डेटा जो है वो फैमिली वेलफेयर डिपार्टमेंट को दिया जा सकता है फॉर व्हाट पर्पसेस, फॉर फैमिली प्लानिंग प्रोग्राम्स, एग्जीक्यूशन ऑफ फैमिली प्लानिंग प्रोग्राम्स, बट दिस माइट आल्सो बी यूज्ड फॉर लेट अस से टारगेटिंग अ पर्टिकुलर कम्युनिटी। फाइन, तो इस सेंस में भी अगर आप सोचोगे तो कहीं ना कहीं ये चीज ठीक नहीं है। दिस इज व्हाट ही इज सेइंग एक्चुअली। तो सर्टिफिकेट ऑफ कॉज ऑफ डेथ, with regard to the facilities available now, the state government could decide that a cause of death certificate should be issued by the medical practitioner who attended the deceased person so that the certificate can be sent along with the death report. So current जो provision है उसके अंडर सपोज अगर किसी को बताना है, किसी को सर्टिफिकेट देना है of cause of death actually, तो provision क्या है कि अंडर this state government could decide that a cause of death certificate should be issued and that to be issued from by a medical practitioner. Fine, but writer ये कहते हैं कि suppose another issue is the areas and the hospitals where such a certificate has been made mandatory varies across states but is generally restricted to deaths in medical institutions only. Means hospital में अगर death हो जाती है तो ठीक है। So the amendments, the recent amendments make it compulsory that for all deaths in medical institutions, a cause of death certificate be sent to the registrar of birth and deaths, and a copy of the same certificate is provided to the closest relative. So now it has been made mandatory. ठीक है। For deaths that occur outside hospitals, then what about them? ठीक है, अभी तो बात हो रही कि हॉस्पिटल में कोई डेथ हो जाती है तो उसके लिए डेथ सर्टिफिकेट इशू कर देंगे कि उसकी कॉज ऑफ डेथ क्या थी। बट व्हाट अबाउट इफ डेथ्स taking place outside the hospitals or the medical institutions? So the medical practitioner who attended to the disease during the person's recent illness has to issue such kind of certificate. But again the writer is posing a question, and that is he is saying this is fraught with problems. What fraught with problems? Especially the issuing of certificate of cause of death outside this hospital or medical institution. Fine. So there are certain problems with this. First, the medical practitioner may not have always arrived at a definite diagnosis before the person died. एक बात है. Second could be the forms for cause of death that are being used are in conformity with the World Health Organization recommendations or not. For example, if the deceased was attended by a practitioner of Ayush system of medicine, जिसको कि हम बोलते हैं आयुर्वेदा, A for आयुर्वेदा, Y yoga, U is यूनानी, S is सिद्धा and H is homeopathy. Fine. So therefore such systems of medicine, the causes of death recorded may not be usable for cause of death statistics since they may not be classifiable under the international classification of disease, because WHO के अकॉर्डिंग अभी क्लासिफिकेशन जो है उसमें आयुष सिस्टम को इंटीग्रेट नहीं किया गया है। तो सपोज अगर कोई मेडिकल प्रैक्टिशनर ऐसा है जो आयुष सिस्टम से बिलोंग करता है, इन एरियाज में डील करता है, तो हाउ कम his issuing of certificate for the cause of death would be admissible or not? This is another problem. Next, the third one is a person who was, let us say, under treatment for a certain disease can die of an entirely different cause outside a medical facility when the medical practitioner was not available for consultation. ये भी हो सकता है कि ट्रीटमेंट किसी और चीज की चल रही थी, डेथ किसी और चीज की वजह से हो गई, ठीक है, या when medical practitioner itself was absent from the scene, let us say, तब डेथ हो गई, then what would be the ground for issuing such a certificate? Another issue. Then fourth and the last is, while section 17 of the act prohibits the inclusion of causes of death in any certificate issued under the act, it now says that the cause of death certificate should be given to the relative of the deceased. Now, so these are contradictory. On the one side you are prohibiting, on the other side you are saying to issue the same. As the cause of death in the death register is taken from the same cause of death certificate issued by the medical practitioner. So when the question itself with respect to the medical practitioner, then how comes this could be issued to the relatives, that you are issuing certificate of cause of death to the relatives. So birth and death certificate, now it is provided that the birth certificate alone would be accepted as a proof of date. आज अभी भी देखते हो कि डेट ऑफ बर्थ की जो आपको ओरिजिनली माना जाता है इंडिया में, दैट इज ऑफ 10th क्लास सर्टिफिकेट, एक्चुअली डीएमसी. So it has been provisioned under this act that the birth certificate alone would be accepted as a proof of date and place of birth for many purposes, such as school admission, issue of passport, and issue of Aadhaar number. So this may not require any amendment in this act or any other act. It should be possible to achieve this through amendments in the rules relating to those databases or even executive orders. So since beginning you see the author is talking about there was no need for such amendment, let us say, but more or less the things could have been done through just executive orders or bringing some changes to the other rules. Fine. For example, while applying for passports, it was compulsory to have the birth certificate for those born after January 26, 1989 under the relevant rules. The present government removed this requirement in December 2016 itself. ठीक है, सो ध्यान रखना कि अब ऐसी कोई प्रोविजन नहीं है. When natural calamities or accidents occur, several persons are reported missing. होता है ना ऐसा कि अक्सर सपोज नेचुरल कैलेमिटी, जैसे अभी बादल फट गए हैं, काफी लोग उसमें बह गए या दब गए या डेथ हो जाती है बिकॉज ऑफ नेचुरल कैलेमिटीज. तो होता क्या है कि एग्जैक्ट सर्टिफिकेट इशू करना मुश्किल हो जाता है एट टाइम्स, कि पता ही लगता है कि डेथ हुई है या मिसिंग है. सो पुलिस जनरली ये कहती है, it has been seen that the police would have to call off the search for them after some time. However, the families of such persons would have to wait for 7 years to request for a certificate that says presumed dead. मान लिया जाता है कि डेथ हो चुकी है. So provision could have been inserted in the act itself, Amendment Act, to register a presumed death when it is reasonable to assume that the person would have died in the calamity or accident instead of waiting for 7 years. This would have helped the family concerned get the death certificates at the earliest possible. Fine. So these are the certain suggestions and certain point of criticism as well for this. Since we have not we are discussing probably the first time this act, right? So that's why it has become important to discuss this and have a clarity about that. Chalo, next is related to the word choice in data protection law, a dilution of rights. Even yesterday we had discussion related to one of the articles dealing with this data protection itself, and therefore the writer is focusing here about the choice. Your choice means citizens' choice related to the data protection law. Recently this passed this act, and a dilution of your rights for the this citizens' rights. So how so? So these are just all the same backgrounds. We're not going into that, but let us start with, while small steps forward may be better than inertia or taking giant and hasty leaps, figuring out how far this law will take us requires that we understand how it protects our privacy in everyday situations and routinely touches our lives. So it becomes important to understand this act in the perspective or in the context of the everyday lives. Find that how this is actually going to protect us in dealing with the routine, let us say, life. So in the search for an answer to this question, we need to look at two basic features of any data protection law: the use of personal data with consent and without consent. So these are the two questions or this features they are actually addressing throughout this article. So standard situation and the issue. The classic problem in data protection is the standard for consent. When your data is being used, do you have a choice in the matter? Suppose whenever your data is being used, so it's about whether the data has been used with your consent or without your consent. This is the first question, the first feature. So for example, your internet activity can be used to study you. An app could find out your religion from what you eat, your health status from your physical activity, or your sexuality from your moving preferences. So maybe either you may have given your phone number to a business while making a purchase, but do not want to be bombarded with marketing calls. It happens generally when you register or give your mobile numbers once, you start getting lots of calls. So as decades of experience in India and other jurisdictions tells us, these are the standard situations that even the most minimal data protection law must address. So how does India's new law deal with such problems? So there are two relevant provisions in the Act. One says that you should be properly informed about what you are agreeing to, and only clear positive actions by you will be taken to indicate consent. So first, though provisions mentioned किए गए हैं related to the consent in the newly data protection, this digital and personal data protection, this act which has become act now, DPDP Act or Data Act in short, you can say. Here you have Digital Personal Data Protection Act 2023. Fine. So first a provision that has been mentioned related to your consent, and that is related to if whether you have been properly informed or not for the purpose your data is being used, and if you have given the positive consent, or indicated positively that yes, you are agreeing with whatever terms and conditions are there, then only it would be treated as that you have given the consent for the use of your relevant data. Fine. But this strict provision is undercut by second provision permitting use of your data if you have voluntarily provided it and have not indicated that you do not consent. So first provision is good, but the second provision, but the first provision somewhere being undercut by the second provision. And second provision ये कहता है आपका कि somewhat permitting use of your data if you have voluntarily provided it and have not actually indicated that you do not consent. So अगर आप ये नहीं कहते हो कि you do not want to give consent, it doesn't mean that you have said that you are that अगर नहीं देने का मतलब ये नहीं है कि आपने what the choice of words is telling if you have not indicated your positive, let us say, consent, then what will be presumed? So if you have not indicated your refusal to the consent, then the governments and the business can assume your consent for various uses without notifying you. So this is the problem कि अगर आपने नहीं इंडिकेट किया है पॉजिटिवली कि हाँ मैं कंसेंट नहीं दे रहा हूँ, नहीं दे रही, तो उस केस में क्या होगी, गवर्नमेंट एंड योर refusal of this indication can be assumed to be your assent. So government and business जो है वो इस केस में, सेकंड केस में assume करके चल सकते हैं कि आपने consent दे दिया है, and that too without notifying you. So that's the problem here. So who is to say you do not provide your data simply by visiting a public place or website or making an online account? After all, provide is not the same as share or transfer. Of course, all three had different meanings. Fine. This ambiguity will result in confusion in courts as well as business uncertainty about the correct standard for consent. So second provision की वजह से there are lots of chaos, ambiguity like situation, and this may translate into the court cases. ठीक है, यहाँ business uncertainty भी देखने को मिल सकती है हमें. So in all likelihood, the weak standard will gobble up the strong one. Strong one is the first one, the weak one is the second one. So it is going to trump the first one, the good one. I mean the bad one is going to trump the good one. Fine. Now the question is about convenience and not the necessity. Fine. So it should be apparent, however, that personal data cannot always be used with consent. For example, or for instance, a person's choice regarding their data can get in the way of various public functions involving verification of identity, targeting of, let us say, welfare programs or benefits and implementation of the laws. So बिल्कुल ठीक बात है कि हर टाइम पे आपसे पर्सनल डेटा जो है कैन नॉट ऑलवेज बी यूज्ड विद कंसेंट. फाइन, कि गवर्नमेंट को कई बार वेलफेयर मेजर्स लेने होते हैं या लॉ एंड ऑर्डर की सिचुएशन है या इंप्लीमेंटेशन ऑफ लॉज है, तो उस केसेस में हो सकता है कि सरकार आपसे कंसेंट ना पूछे, बिकॉज दीज आर द सिचुएशंस और लेटेस्ट इमरजेंसी काइंड ऑफ सिचुएशन है, वायलेंस कहीं बहुत ज्यादा हो रही है, तो वहां पे सरकार आपसे कंसेंट पूछने में थोड़ी टाइम खराब करेगी, सीधी सी बात है. So these functions can be thwarted by misrepresenting or withholding information, but does that mean there is no protection for such data? बट इसका मतलब ये नहीं कि सरकार अपनी मर्जी से यूज करी तो उसके लिए कोई प्रोटेक्शन ना हो. मीन्स हमारी जो डेटा है, जो पर्सनल इंफॉर्मेशन रिलेटेड है, वो कहीं ना कहीं प्रोटेक्टेड होनी चाहिए. So in previous drafts of this new law, because this law which has been finally become this act or law, you can say, actually it has been making from the last many years. Fine. So therefore, in the previous drafts of the new law, this one, your personal data could be used without consent only if it was necessary for a specified purpose in carrying out certain legitimate state functions, meeting legal requirements and dealing with emergencies. तो उसमें क्लियर कट मेंशन था प्रीवियस ड्राफ्ट में रिलेटेड टू दिस लॉ जो गवर्नमेंट ने वापस ले लिया था. इसमें क्लियर कट मेंशन था कि हम क्यों और किस कॉन्टेक्स्ट में आपकी डेटा को यूज करेंगे विदाउट योर एसेंट. बट ऐसा कुछ इस करंट वाले में मेंशन नहीं है जो कि अब एक्ट बन चुका है. So it is important to therefore understand the significance of this. Sometimes consensual processing of data is very much feasible if inconvenient. Even if consent is not feasible in such a situation of, let us say, law and order violence की situation है जहाँ पे कि consent feasible नहीं है उस टाइम पे at a point of time, specific methods can be used for identity verification, or the use of sensitive data on health, religion, political affiliation and sexuality may not be strictly necessary when designing and implementing many kinds of public programs. For example, तो ऑथर्स ये भी कह रहे हैं कि कई बार नहीं भी जरूरत होगी कंसेंट इस तरह के डेटा की. क्यों? तो दे आर गिविंग एग्जांपल. फॉर एग्जांपल, इंफॉर्मेशन ऑन मेंबरशिप इन अ ट्रेड यूनियन. So it's a good example. Information on membership in a trade union is not necessary in assessing a job application, even if the employer thinks it is relevant for their purposes. Fine. So it's a good example. If data is allowed to be processed even when it is not necessary, those doing so will always choose the more convenient route. Of course, privacy will always be the low priority. This is exactly what the 2023 law does. It allows processing without consent. So that's the issue. That's the point of criticism. When it is for and not necessary for certain legitimate uses, this small change in wording will make a huge difference in the actual level of protection provided. Fine. So this is the issue with the current Data Protection Act. An area of concern. Now where the concern lies according to them. So what is more, when your data is processed without consent, of course that's a bigger issue or concern when some of your personal data being processed, let us say by government agencies or private business enterprises without our consent. You will neither be notified of this nor subsequently be able to confirm it. If you somehow find out that your data is being used, you will not have the right to get incorrect data corrected or unnecessary data erased. So data taken for one non-consensual purpose can be freely used for others. बिल्कुल ठीक बात है कि एक बार अगर अब डाटा आपकी डेटा यूज हो जाती है without your consent, then of course it can be further used for other purposes as well. This is despite the fact that the Supreme Court of India has held principles such as necessity and purpose limitation to be part of the right to informational privacy. So right to privacy जो जजमेंट दी थी 2017 में, कल भी हमने देखा था जस्टिस पुटा स्वामी केस जो था उसमें, तो सुप्रीम कोर्ट ने ये कहा था कि दो जो चीजें हैं वो ध्यान रखनी चाहिए, दैट इज नेसेसिटी, कितनी जरूरी है, फाइन, कंसेंट की या विदाउट कंसेंट, एंड सेकंड इज पर्पस. सो these two wordings, let us say necessity and purpose, should act as a limitations on the part of the government or any agency or fiduciary, those who are data collectors actually using for and processing the same. So therefore these two, that is necessity and purpose for the data collection and whether and necessary hai ki nahi, these two should act as limitations on the part of such agencies. Others elsewhere have raised serious concerns about the way the new law deals with the rights to information and free speech, surveillance reform and the regulatory structure. So इस डेटा की प्रोटेक्शन एक्ट की वजह से कुछ राइट टू इन्फॉर्मेशन की क्लॉजेस पे भी कुछ इश्यूज आ रही हैं, या वहाँ भी कुछ जिसको कि हम ऑलरेडी डिटेल में डिस्कस कर चुके हैं. सो आई एम अगेन नॉट गोइंग टू दैट. On the other hand, while the issues described in this article may seem like legal technicalities, but of course these are the relevant ones. So if you want this law to meaningfully protect personal data, it is essential that we find ways to tackle these shortcomings that has been underlined by the writers. Fine. So a new insight actually mentioned in this article, that's why, because though they are lawyers and so therefore they are giving more or less the legal technicalities or technical evidences. Now the next is in question answer format. You have, is there a need to replace the IPC, the CRPC and the Evidence Act? So there are two people today, प्रकाश सिंह, एक केस भी है प्रकाश सिंह वर्सेस यूनियन ऑफ इंडिया, बहुत फेमस केस है रिलेटेड टू द पुलिस रिफॉर्म्स दैट वी स्टडी इन द गवर्नेंस पार्ट of your syllabus. And second person is Shahrukh Alam. She is an advocate at the Supreme Court. So the question is there a need to replace the IPC, the CRPC and the Evidence Act? जैसे कि हम कुछ दिनों से डिस्कस कर रहे हैं कि सरकार ने हिंदी नेम्स के साथ इनको रिफॉर्म करने की बात कर रही है एंड सिलेक्ट कमेटी के पास बिल्स को भेजा गया है. So how different are the new bills from the prevalent laws? Prakash Singh ji जो है former DGP, it is true that the Indian IPC, CRPC Code of Criminal Procedure and the Indian Evidence Act were fully operational. Their sections were utilized in the criminal justice system and the public had become used to it. But it would have been exaggeration to say that they reflected the changing values and the democratic aspiration of the people. कहते हैं कि ठीक बात है कि ऑपरेशन में है, लोगों को आदत भी होगी इसको यूज करने की काफी टाइम से, बट इट विल बी एन एक्सैजरेशन, फाइन, कि कहीं ना कहीं ये चेंजिंग वैल्यूज एंड डेमोक्रेटिक एस्पिरेशंस ऑफ द पीपल है उसको भी रिफ्लेक्ट करता है. सो दिस वुड बी समवॉट. सो देयरफॉर ही इज सेइंग that the entire socio-economic scenario and political complexion have changed since 1860, the year in which IPC was actually enacted. Fine. So he is saying, I think the need was felt that these laws should reflect the change. But what Shahrukh Alam ma'am is saying, it is very true that the codes, all these three codes, probably did not fully reflect the change in society, but there seems to be some ambiguity about how these new laws would relate to all the precedents, jurisprudence and case laws that were developed on the basis of the old codes. तो ये कह रही हैं कि इशू ये है कि बेसिस ऑफ दिस ओल्ड कोड्स, आईपीसी सीआरपीसी जो है अंग्रेजों के टाइम की, इसके बेसिस पे जो प्रेसिडेंट्स हैं या जो जुरिस्प्रूडेंस है, दैट इज थ्योरी ऑफ लॉ एक्चुअली जुरिस्प्रूडेंस, एंड केस लॉज, डिफरेंट जो केसेस रिलेटेड टू लॉज रिलेटेड टू द केसेस हैं या केसेस हैं, यहाँ पे हम डिस्कस भी करेंगे केदारनाथ वर्सेस स्टेट ऑफ बिहार और डीके बासु वर्सेस वेस्ट बंगाल. तो जो भी डेवलपमेंट्स हुई है इन केसेस में कहीं ना कहीं ऑफ कोर्स उनको अगर देखें तो रेलिवेंस है इनकी जो ओल्डर वंस है. So there is a debate going on across the world in terms of criminal justice jurisprudence, which talks about keeping someone in detention without being charged. In Scotland, the amount of time for which you can keep someone in detention without bringing charges against them is just 6 hours. However, in our country, it was 60 days. And the new bill actually proposes 90 days की बढ़ा के 30 days की और एडिशन कर रहे हैं. Fine? किसी पर्सन को आप डिटेन कर सकते हो without even having framing the without the charges having framed for earlier 60 days, now for 90 days. So she is in disagreement with this. Fine. Another point is the new CRPC also seems to give a lot of discretionary power to the police, like the right to handcuff, which we have never had in India. Now there's discretion to handcuff to arrest women after sunset in exceptional circumstances and to use any force and means necessary when arresting a person that would legitimize encounters and all kinds of violence. So these are the point of you can say the questions or the disagreement point where she is raising. So of course we have addressed this, that the new Bharatiya Nyaya Sanhita bill allows custody from 15 days which can go up to 90 days as so. According to Prakash Singh, there is general consensus that these bills should not be pushed in a hurry. Now that the bills are in public domain, let the general public comment on them. As far as handcuffing is concerned, he is saying, I do not think anyone understands how big of a concern it is for police. It is all right for the Supreme Court to say in the DK Basu versus State of Bengal 1996 case that the people should not be handcuffed. But at times, from the police के अगर perspective से हम सोचने की कोशिश करें, तो he is saying, I have seen If you see the practices in many democratic countries, I have seen heads of a state being handcuffed. Fine. In India, even if a man is a member of mafia, you can't handcuff him. And then why should you force me to touch somebody? He might have some skin disease or something else. Fine. So this is his argument. Madam Shahrukh Alam is saying, this has become part of the actual provision in the bill, so we have gone past the stage of debate. Case laws like D.K. Basu and Kedarnath versus the state of Bihar 96 to judgment by the Supreme Court of India that upheld the validity of sedition law actually have set down some laws. So कहीं ना कहीं कुछ laws जो हम देखते हैं, जैसे ये बहुत famous केस है केदारनाथ सिंह, that is with respect to the sedition charges, देशद्रोह का जो मुकदमे होते हैं. So what would you say are the similarities between the existing law and the new laws? Now the question is about the similarities between the recent one and the existing and the new ones. So Madam Shahrukh Alam saying, she is saying there are very much similarity. Violence is still going on and detention without charges is still going on. The bills endorses, legitimizes, formalizes these practices, so there is no substantial departure. Okay. Mr. Prakash Singh, he is saying a lot of it is old wine in new bottles, but of course there are changes. The bills have introduced certain new sections. For example, in the Bharatiya Nyaya Sanhita bill, terrorism has been defined, organized crimes have been added, and sedition has been repealed. So subversive activities have been added and it needs to be defined. There are new provisions regarding community service, mob lynching has been defined, and as an offense, and stricter punishment has been proposed for crime against women. So all these are the positive ones. Fine. Next is, usually laws are changed when they become obsolete. Are there any provisions in the IPC, CRPC, in the Indian Evidence Act that according to you are being misused? So of course there are articles which have been misused. For example, so Prakash Singh is saying certain sections are misused, but the misuse of an act does not make it irrelevant. You have to find ways to prevent the misuse rather. Madam Shahrukh Alam is saying the courts had already decriminalized consensual sex between adult gay men. Section 377 was read down, but non-consensual sex was still an offense. Fine. So these are the issues. On the other hand, for example, love jihad, which has been defined as concealing your identity before marriage in the Bharatiya Nyaya Sanhita bill, has been made into a separate offense and the sentence is of 10 years. In the same bill, sexual offenses are separate chapter, but that is limited to sexual offenses with respect to women. Fine. So it has forgotten about sexual offenses perpetuated by men on men or women on women. So this has been left out. So are there welcome changes in the new bills? Final take of these two experts. So Prakash Singh is saying yes, certainly. The fact that they have attempted to define terrorism is a step in the right direction. It is good that the organized crimes have been defined here. Once the trial concludes, the judgment has to be given within 30 days. So this is again a good provision. Fine. So only 2 adjournments are allowed. So these are the welcome changes. Madam Shahrukh Alam saying there are some provisions that say if you can't finish the trial within 6 months in petty offenses, then that person will not be tried. So that is welcome. But this pertains to only petty offenses and has not been linked with serious offenses. Petty offenses means daily routine offenses jo hote hain, chote mote crimes, not the serious offenses. Fine. Apart from this text and context from this page, the only important thing for the day is recently you see India tops AI projects in the GitHub. GitHub is actually a platform where the developers interact and use this platform for developing AI related projects, you can say, or softwares. So according to Stanford latest index, that is Artificial Intelligence Index report, software developers in India contributed to over 24% of AI related projects in this GitHub. This GitHub is a platform, as I said. So remember, Artificial Intelligence Index released by Stanford University. That's it about this. There's lots of comparison. India ye koi institution nahi hai. If you see in the top 10, most of them are the Chinese ones, and then MIT at the last 10th position. So what else important from the today's newspaper? Quickly let us have a look at it. Okay, so President has launched a warship that is named Vindhyagiri. So there was a project actually going on, and this name is Project 17A. Fine. So under this is the last in the series of 3 Project 17A frigates built by the smaller warships actually. by the Indian Navy at the Kolkata-based Garden Reach Shipbuilders and Engineers. Fine. So this is what President has said, that India's this will enhance India's maritime capabilities, and this is a step towards achieving the goal of Atmanirbhar Bharat through indigenous shipbuilding. Fine. So remember, 3 frigates were actually to be built under this, and finally, okay, DRDO's former chief Arunachalam has died, and okay. What next? NEP, National New Education Policies, a flexible policy, states free to adapt according to their requirements, said by the Finance Minister. Okay, politics only. So with huge allocation, technology will transform judiciary, said by CJI, because in this year's budget, current budget, 70,000 crore rupees has been earmarked for the phase 3 of the e-courts project. Fine. So very optimistic. Flood forecast app has been launched by Water Commission, Central Water Commission. Remember, Central Water Commission. Fine. Called Flood Watch. तो ध्यान रखना ये किसने रिलीज किया है, काम समझ सकते हो इसका क्या होगा. Another thing, WHO chief, that is Tedros Adhanom Ghebreyesus, Director General (DG) of WHO, is asked nations to unlock the power of traditional medicines. For example, आयुष की हम जैसे बात करते हैं इंडिया में, so again it's a part of traditional medicine. ठीक है, तो इन्होंने कहा है, and अभी there are certain additional information here. For example, he was speaking at the WHO first global summit on traditional medicine as a part of the G20 health ministers meeting in Gandhinagar. So Gujarat declaration, since Gandhinagar में हुआ तो Gujarat declaration. So Gujarat declaration is related to what? The question might be asked anywhere. So Gujarat declaration is related to actually the traditional this system of medicine. ठीक है, so इस चीज का ध्यान रखना. Quickly. Okay. Supply shocks not over, inflation to be well above 6% in Q2. Fine, said by the RBI. ठीक है, so supply shocks हैं, जैसे food में inflation देखने को मिल रही है, retail inflation to fall below 7% in August. Fine, from the 15-month high of 7.44% in July. ठीक है, so you can see RBI is saying it will be above 6% but below 7%, another forecast. So somewhat it will be above the upper limit of this monetary policy committee, that is 6% inflation should be there in the country at the upper limit. Fine. India said to consider Russia wheat import at rebate to cool prices. So India is considering to import wheat from Russia in order to cool down prices or cool down inflation in the country. Fine. Okay. What next from this world page? China assures support for Sri Lanka's debt relief ahead of crucial IMF review. So China and Pakistan, all with their friends. This is what the duty of all with their friend, to stand by the other side. Okay, and now we have this sports page. So finally, we have discussed whatever the relevant and important articles and miscellaneous facts were there from the both preliminary and mains exam point of view. Before we stop here, let us quickly see the questions from the today's this discussion itself. So here comes your today's questions. In which among the following releases the Artificial Intelligence Index? And second is there a need to replace the IPC, the CRPC and the Evidence Act? You need to comment. The question is for 15 marker and you need to write the answer into 50 words. So that's it from my side. If you have any query, anything for the, from the day, you can put the same in the comment section. Until then, take care, keep revising and stay tuned for the tomorrow's Hindu analysis. Thank you.